Assalamualaikum and greetings to everyone. It's my pleasure to introduce myself. My name is Asma Izati binti Azizuddin. I live at Kampung Bukit Petiti Manir, Kuala Terengganu, and I'm a Malaysian citizen. A little background of my academics. I received my SPM in 2016 at Sekolah Menengah Kebangsaan Agama Datuk Haji Abbas. Then I graduated with a diploma in law from UNIZA, and now I'm pursuing my second year in Bachelor of Law, also in the same university. My aspiration for my future legal career is to become a solicitor. Despite the competition and entry difficulties this sector is known for, I would like to challenge myself. In relation to the actual sector I wish to work in, I'm still unsure, but hopefully I will find it during my internship in the future. Hi, I'm Asma Izati, the legal advocate and solicitor of Asma and Partners. At Asma and Partners, we handle many different types of business and contract litigation for clients across Terengganu. Today, I'm going to discuss a very necessary issue which affects many businesses, especially in this pandemic situation that we face now. Following the sharp increase in the number of COVID-19 cases in Malaysia, the government of Malaysia had declared the imposition of Nationwide Movement Control Order (MCO) effective from 18 March 2020. As a result, parties to a contract are beginning to feel the effect for not being able to perform its obligations under their respective agreements. The issue that I'm going to discuss is whether the MCO could cause breach of contract. When discussing this issue, first and foremost, it's important to understand the general meaning of breach of contract. A fundamental breach of contract happens when one party fails to perform its contractual obligation as set out in the agreement. So does it mean that they had breached their contract? The answer is no. Upon enforcement of the COVID-19 Act, Section 7 of the COVID-19 Act relieves businesses and individuals from the performance of their contractual obligation retrospectively from 18 March 2020, provided that the inability to perform such contractual obligations is due to the measures prescribed by the authorities to control or prevent the spread of the COVID-19 under the Prevention and Control of Infectious Diseases Act 1988, or better known as PCID Act. Second, the answer is it depends on the terms of the agreement and the relevant facts and merit of each case. More often than not, the relief from non-performance will be found in the contract itself in the form of force majeure provision. A force majeure provision is a clause that relieves the parties from performing their contractual obligation in the event of unforeseeable occurrences. If the defaulting party successfully proves that the downstream consequences of COVID-19 fall within the scope of the force majeure clause, the defaulting party will not be liable for breach of contract. In the absence of express provisions in the contract, the court is typically unwilling to imply a force majeure clause into the contract. In such circumstances, the defaulting party may consider asserting his defense under the doctrine of frustration. The doctrine of frustration is found in Section 57, Subsection 2 of Contract Act 1950, where it stated that the act will become unlawful or impossible after the contract is made, The contract shall then be deemed as void. A frustrating event will discharging the contractual obligations of the parties, as the parties' contractual obligations have become radically different from what was envisaged at the inception of the contract. To sum up, MCO does not cause a breach of contract if a party can prove that either the contract falls under Section 7 of the COVID-19 Act, contains force majeure provision, or the contract is frustrated. Again, I'm Asma Izati, the advocate and solicitor of Asma and Partners. If you are dealing with a legal dispute, give us a call. Let's discuss how Asma and Partners can help your family or your business.